Servier Laboratories is not accepted.
Good morning, my lord. Please the court, at the close of the hearing yesterday, I was clarifying the litigation context in which the judge came to order the trial of the preliminary issues in January 2018. If I may, I return to the transcript at Supplemental Bundle 6 briefly so that I can complete a couple of points. What we saw yesterday, to summarise, was that the judge envisaged that the trial would be the occasion to test Servier's pleaded allegations about a set of measures that the health services reasonably had to take at a national and local level within the framework of the principles governing failure to mitigate loss and contributory negligence. He considered, as we have seen, that this would principally be done by receiving expert evidence about whether each of the actions pleaded by Servier, the measures, constituted generally accepted good practice at the time. The response to his proposal by Servier's counsel was to maintain the submission that disclosure from all of the PCTs was needed, and her reasons for that need to be looked at. What she said was that full disclosure was required in order to assess what was generally accepted good practice. And in a nutshell, the judge did not accept that that was a valid reason for ordering full-scale disclosure ahead of the adjudication. If you have the transcript in tab 6 of the supplemental bundle and look on page 52, you have the page 25 in the top right quartile. Counsel, 5 lines down, until we have disclosure from a sufficient number of PCTs, we cannot really say with any certainty what was well known. It gets back to, that was a point made by their economist, that if you only have disclosure from 11, you might miss the PCTs. There might be more than 11 where it's mentioned that that's being done or ought to be done. Judge, but an expert would be unaware of that. Counsel, if we have not had the disclosure that provides the expert with the basis for that statement, it's going to be very difficult for the expert to make the statement. Judge, you would say that nonetheless, although your expert is unaware of it, the manager of a PCT should have been aware. Counsel, no, I'm simply saying the expert's consideration of what was known will be informed by the disclosure that's given. Judge, I hear what you say, which ended the exchange. So the preliminary issue envisaged by the judge was ordered following that CMC. There isn't a judgment, I believe. The point that emerges from the hearing transcript is that Servier accepted the proposition that the exercise was designed to clarify what amounted to reasonableness in the circumstances of these damages claims in order to test its pleaded case, namely that by reason of the circumstances set out in paragraph 83B of its defence, they're all interchangeable and the others are cheaper, all PCTs should have taken the steps set out in paragraph 83 of the defence. The arguments mounted by Servier's counsel at the CMC were put on that footing. So what was envisaged was an exercise in which each of the 7 pleaded mitigation measures would be considered to see if Servier's case stood up. What was not envisaged was that if the court was to rule against Servier, Servier would say that this was not the end of the matter because it had a fallback case which did depend inevitably on wide-scale disclosure. Specifically, if the court were to decide there were no general standards representing accepted good practice, and it was all a matter of individual entities wrestling with individual priorities and constraints and circumstances, that would dispose of the plea. So far as concerns the type of evidence appropriate for the preliminary issues trial, you'll be aware that there was factual evidence and it was not merely restricted to expert evidence. To explain that, this point was picked up again on day 2 of that CMC in January 2018. In short, the health services submitted that to best explain what the institutional setup was and how best practice was communicated to PCT managers, whether it was through guidelines or an intranet or bulletins or conferences or matters of that kind, it could be informative to have illustrative factual evidence from some individuals who had worked at local PCTs. And the judge addresses that suggestion in the transcript, which you have as at tab 7, page 68, bottom left quartile for efficiency, lines 6 to 11. Council's submission on this.
So 6 to 11.
6 to 11 is the judge's statement. He says it may be you don't do it through an expert. It may be you do it through a couple of illustrations explaining what were the factors they took into account and why they didn't do this and why they did that. It may be that in the end it's a more satisfactory way of doing it.
Sorry, I wasn't keeping up. Which page?
I'm sorry.
is that?
32.
32.
Yes, it's page 68 of the bundle
Yeah.
and internal page 32, bottom left quartile.
Yeah.
Council's submissions are immediately above, in the top left, lines 13 and following, and then the judge's ruling on the point.
Yeah.
So the judge therefore entertains the notion that to illustrate how things are done in the NHS, you could have some factual evidence of that nature. That's all I propose to say about how this was, yes.
You said there wasn't a judgment, but there must have been an order, Mr. Turner.
There will have been an order. I'm not sure it's in the bundle.
No, never mind whether it's in the bundle.
There was an order.
There was some discussion yesterday as to whether there was anything that could have been appealed.
Yes,
But if there was an order,
there was an order setting
then
down.
it was something that was capable of being, or in relation to which at least permission to appeal could have been sought. Now, of course, it may have simply been dismissed because it was a case management decision. But there was no attempt to appeal it, was there?
No, there was not. There was an order, and I apologise that it's not in the bundle. Please may we now return to the chronology at tab 4
Yes.
in the court.
Just before you do, as I understand it, by the end of the 22nd of January, no one was really resisting the idea of preliminary issues,
No,
and hence no need for a judgment.
that's right. It had been fully debated at the hearing, and the judge didn't therefore need to give a reasoned ruling. He simply made the order.
Yes, I see.
But he presumably gave directions for leave to call expert evidence, witness statements, disclosure, and so on.
I will have to check the terms of the order, my lord. I don't want to misspeak. I'll do that at the short adjournment. If I may return to the chronology.
The judge, there's some debate at the end of the hearing on the second day.
Yes.
About what's going to be in the order, which seems to be the judge contemplating the council prepared an order, so I imagine it was done.
Yes, there was an order. I can't answer to the particularity of it, I'm afraid.
My lords, if it may assist, we'll obtain a copy of it and.
Yeah,
if-
it probably would be.
Yes, I think it's probably a lot is turning on this now, so we probably need
Because
to.
one would expect it, as my lord says, to have dealt with witness evidence, experts, etc.
Yes, let's get a copy of it.
Thank you. Yeah, sorry, so we're going back to.
So now we go back to the chronology.
Yeah.
And one sees from the chronology, tab 4 in the core bundle, that in October 2018, Yes, this must have been the subject of directions.
Yes,
There was an exchange of factual evidence, and that was followed by a hearing in November 2018, at which the judge enlarges the trial fixture to 22 days, 15 court sitting days. Servier then brings an application to vacate the trial in January 2019, which follows the handing down of the General Court judgment in Europe in December 2018. It was on the 12th of December. You've heard from my friend that as part of the application to vacate, Servier made the arguments which are shown in its counsel's skeleton for the hearing, which are back in the supplemental bundle at tab 8, and to which I'd invite the court to go once again.
Yeah.
So this is Servier's skeleton argument in support of its application to vacate. The key paragraph for present purposes is indeed the one that Mr. Saunders took you to, which is on page 79. At subparagraph D in paragraph 30. And about 8 lines down in that paragraph, the sentence begins, for example, Miss Watson, who was one of the factual witnesses whose evidence by now had been served in the statement, says that Plymouth saved a certain amount of money from a relatively modest incentive scheme, and she emphasises that each PCT would have distinct local priorities which depended largely on the demographics of its area, for example, as to age, ethnicity and income deprivation. And you'll see that Servier apprehended from this that if one accepted the written statement of this PCT witness, it might be found at the trial that each PCT would have distinct local priorities, depending largely on the demographics of its area and so forth. And Servier therefore argued that what might happen is the court would conclude that as a matter of accepted good practice, some or all PCTs needed to take at least some of the steps to satisfy the duty to mitigate, but the precise content of their duty, what steps were required in each case, would all have to be investigated at a local level because of the individual circumstances of the PCTs. There was, however, a quite different way of looking at this. And this was that the health services might succeed in showing that there were no generally applicable minimum steps that some or all PCTs were reasonably required to take to mitigate loss from Servier's behaviour, no general standards, and that it was indeed down to individual judgment in the light of each PCT's local priorities and constraints. Yeah. In that event, Servier's defence of failure to mitigate, which it had been pursuing in a determined manner for the last 2 years, would fall away. And this is the point that was made and accepted in terms by Servier's counsel when it came to the hearing in January 2019. So you turn to supplemental, the next tab, tab 9 in the supplemental bundle, look at page 86. You have the submissions of Servier's counsel on this in the top right quartile, internal page 17. And reading from line 3, she says, certainly if we win, that's Servier, on mitigation, I'm sure that Mr. Turner will still say, well, even if it might have been reasonable for some parties to do some things, that would not have had very much of an effect. So the effectiveness question will still remain. There will still remain the question of what PCTs actually did, which is the reason we started this entire debate about disclosure, to find out what they did. All of that, which is really the difficult part of the case, the expensive part to try, because you'll have to look at economic evidence, that would all remain. So you would actually, it's going to be a very expensive trial to determine a very small issue, not likely to make a difference to settlement. The judge's response at line 22, very crisply, I mean, if the claimants succeed, the mitigation defence would fall away. Counsel, that is right. That is why we started this. Because of the cost and complexity and time of disclosure, yes. On looking at the whole of the mitigation defence, including effectiveness. Servier's application to vacate the trial was therefore refused. The terms in which the judge gave his ruling, which again was not appealed, is in the authorities bundle at tab 3, authorities bundle 3 at tab 16 at the very end. In this ruling, he explains why he has set down the trial of the preliminary issues, and he explains his assessment that if it's decided one way, it will obviate massive and expensive disclosure, in his words, by the public authorities. He also notes that the trial estimate has enlarged to 22 days, including 15 court sitting days, but he gives reasons for concluding that it's appropriate to go ahead as a matter of case management in any event. And to show you these points briefly, paragraph 12 on page 777 is the starting point at the bottom of that page. He says that when the matter came before me in January 2018, it became clear that the attempt by the economists to find a way to keep disclosure within proportionate bounds by a form of sampling had not been successful. They were very far apart. Then over the page, at 14 to 15, he explains what he did. Following urging by the court, what was adopted was a rather different course. And he explains his decision to set down the preliminary issues, to formulate preliminary issues as the Chancellor has suggested, which focus not on effectiveness, but on the reasonableness point. And he explains that Servier resisted that in paragraph 15. He was not persuaded. Finally, over the page at 21 and 22, he is dealing there with the submission that now that the General Court's judgment in Europe has just been handed down, there's another reason to postpone the preliminary issues trial. And in the last 4 lines of 21, he points out that much work has already been done in preparation, including the service of all the factual witness statements. And at 22, he says he was reminded that this preliminary issue will not resolve the case whichever way is decided. They will, however, if decided one way, obviate massive and expensive disclosure by a whole series of public authorities. And that's, to my mind, a very relevant consideration.
Sorry, which paragraph is that?
I'm sorry, that is paragraph 22,
Oh, yeah.
and it's the second sentence. So that's how he explains his decision to go ahead, including with the enlarged time estimate. Servier doesn't...
It's quite clear there that when he says if decided one way, he means if decided in favour of the claimants.
Yes.
Yeah. Because if decided in favour of Servier, then you would have to have the question of effectiveness.
That's right, yes. And Servier's counsel was therefore correct to point that out in the part of her submissions that we looked at a moment ago. So his reasoning, his judgment was that if it's decided in this way, it will obviate all of this. Servier doesn't seek to appeal, again. Instead, it mounts a new argument. It says that certain of the findings of fact which have been made by the European General Court in the European litigation are binding in the English damages claim and would be binding in the preliminary issues trial as well. And that argument then travelled up. It was dealt with at first instance and rejected. It was dealt with by the Court of Appeal and rejected. It went to the Supreme Court and was rejected. So it went up to the Supreme Court and was dismissed by their lordships in November 2020. After that detour, preparations for the preliminary issues trial started again. There was a PTR before the trial in May 2021. In its skeleton for the PTR, Servier suggested, as you heard from Mr. Saunders, that it intended to argue at the trial that at least some of the PCTs should have taken steps to reduce perindopril prescribing, depending on their local circumstances, such as to satisfy the duty to mitigate loss argument that they were raising. So they then say, we are going to be saying that local circumstances are a factor that do need to be taken into account as part of the plea that will be adjudicated on. Mr. Justice Roth's ruling on that, which you have seen briefly in Mr. Saunders' opening, is in the Fourth Authorities bundle at tab 18. There's only one paragraph in that I need to show you, which I referred to at the beginning of my address yesterday. Tab 18.
Yeah.
We have already looked at paragraph 4, which was important, where the judge records his reasons for having the trial, and it was recognised that this could be dealt with looking at the claimant's conduct on a more general basis. But at paragraph 11, what he adds is, it's quite clear to me, this was in view of Servier's statement in its skeleton argument that it intended to run this additional point. In the second sentence, the trial which will take place is a trial of the issues as ordered. There has been no application to make a further amendment to the defence. Any such application would have had to be considered, and I think would be the only basis on which the scope of the preliminary issues ordered could change.
So the judge at least seems to have thought that this case that they're now seeking to run wasn't within the existing pleading.
That's right. That's right. The argument on all sides had not envisaged that this was going to be within the pleading. You've seen how Servier described their position even now in paragraph 54 of their skeleton argument in the first sentence. And he considered that it would require an amendment if they were going to be striking out in this different direction. So, to draw the strands together, you have seen the basis on which the judge made his decision to order the trial of preliminary issues. It was a matter of reasonable case management of very unwieldy litigation. And further, Servier sought on various occasions after the order had been made to prevent it from going ahead, but accepted in terms that if the health services won on the issue of reasonableness, their mitigation defence would in totality fall away. And that is what has occurred. So, my lords, I say no more about the context. I turn, in view of the time, directly to Mr. Justice Roth's judgment, which you have in the core bundle at tab 6.
Yes.
In general terms, both in its skeleton and in the oral submissions that you heard yesterday, we say that Servier presents a picture of the reasoning in the judgment that is incomplete and inaccurate. And what I shall do is begin with the judge's analysis of the threshold preliminary issues, A and B, concerning the interchangeability of Servier's drug with other drugs in the class, ACE inhibitor drugs. The main section begins on page 124, the bundle numbering, and you see the heading, Issues A and B, halfway down the page. And you're aware that Servier asserts in this appeal that the judge effectively agreed with a substantial part of its case on those two issues. It says so in its skeleton at paragraph 33, and Mr. Pitchnan even told the court yesterday that Servier won on this issue in relation to the question of drugs suitable for patients with straight or uncomplicated hypertension. In paragraph, we'll go on to it, 230, subparagraph 1 of the judgment. Now, the judge himself said in terms in his consequentials ruling at tab 7, page 186, paragraph 6, first sentence, this fundamentally misrepresents his judgment. The court did not find that Servier substantially succeeded on these issues. Servier's pleaded case was categorical. It alleged there were no circumstances in which it wouldn't have been clinically appropriate to prescribe another drug instead of perindopril, except where the patient was allergic to or intolerant of all other drugs. The express premise for the failure to mitigate case was that subject to that limited qualification, perindopril was generally interchangeable with the other drugs. And the judgment finds that this is incorrect. Contrary to the underlying premise of the mitigation case, paragraph 83b, he found there were very many situations where a prescriber could reasonably have decided that the best interests of the patient was to give them perindopril and that the drugs were not interchangeable. And to see that, if we can begin with the explanation by the judge of how he was approaching the issues. And if you go to page 126, 2 pages further, you see paragraphs 175 and 176, which need to be read together. 175, he says that in my judgment, if in certain circumstances a prescriber could reasonably consider in the light of the knowledge and understanding at the time that perindopril offered a real advantage for her or his patients compared to other drugs, it would not have been reasonable or appropriate to prescribe another drug. By advantage, I include the possibility the clinical benefit was better established than for the alternatives, such that the prescriber could objectively viewed be more confident of the likely effectiveness. And I also include non-clinical benefits such as convenience. Moreover, aside from potentially relevant circumstances of the particular patient, I think that to the extent there was a lack of consensus among acknowledged specialists, that could preclude giving a uniform answer to the question which the two issues pose. And then he says this: clinicians who had to decide at the time which drug to prescribe will not have had the benefit of hearing the views tested, having the underlying scientific papers analysed, and observing experts subject to cross-examination as occurred during this trial. And he continues in the following paragraph, picking it up at the third line. If and to the extent that there was at the time a respectable body of opinion that regarded perindopril as the most appropriate drug to use, in my view, that's very significant when asking what the claimant should reasonably have done to seek to persuade doctors to prescribe another drug instead. So in short, the judge's point about the phrase respectable body of opinion, which was picked up on the other side yesterday, that regarded perindopril as the most appropriate drug to use, was simply referring to a body of acknowledged specialists at the time. He was not suggesting that there would only be a respectable body of opinion if it was in line with the cross-examination of Dr. Coulson in the trial. On the contrary, he specifically, at the end of 175, rejects this suggestion. Moreover, if a prescriber does follow a respectable body of opinion of acknowledged specialists to decide that the best interest of their patient lies in selecting perindopril, that would be an objectively rational basis for their decision. In other words, that's why it would be reasonable. The sorts of practical factors which the judge found were particularly important to forming a reasonable primary care prescribing decision included two matters: frequency of dosing, how often you take it, and ease of titration, which is you start on a low dose and then you up the dose in increments until you get to the optimal so-called maintenance dose. Those two matters, frequency of dosing and titration, were features where perindopril had advantages and where the judge found in this judgment that Servier systematically exploited those advantages in its efforts to promote its drug as being non-interchangeable and better. If you please flip forward to page 177,
Page 177.
which is paragraph 162, the important paragraph on the Servier conduct issue that Mr. Saunders took you to yesterday. You see halfway down this paragraph that this point is mentioned. So he's talking there about an underlying strategy document of Servier's, which contained both promotion strategies and deflection strategies, trying to stop PCTs from behaving in a way that would mean that they encourage the prescribing of cheaper drugs. About 8 lines down, the sentence reads, "The document summarises relevant clinical arguments with charts, graphs, and footnote references to academic studies, and practical arguments in terms of titration and dosages," before going on to deflection strategies. Starting with frequency of dosing, if you go back in the judgment to page 127, at paragraph 180 at the top of the page, you can read it for yourself. The judge refers to the importance of this point, frequency of dosing, and what the witness had said about it. The patient compliance is likely to be lower where the drug's more complicated to take. At paragraph 182 below, he refers to what Servier's expert, Professor Brown, said. He agreed that some drugs are more convenient in terms of administration than others, and that once daily dosing is relevant to the clinical decision of which drug to prescribe. And now, if I may, I'd invite you to look at the underlying document that the judge was himself referring to in paragraph 362. It's in the supplemental bundle at tab 2. And if you go in that to page 4 of the bundle, the second page in, under the title hypertension, which is the major condition that this drug is used to treat, records in the first sentence that hypertension, the main disease GPs manage, is that which accounts for 70% of the patients. And then in the second paragraph, perindopril has consistently proven to deliver a better quality of blood pressure control than the other ACE inhibitors, or ARBs, as measured by trough to peak ratio. This means perindopril is a true once-daily therapy, offering the maximum daily level of blood pressure control and therefore maximum protection. And it goes on in the third paragraph, it goes on to say that studies comparing the ACE inhibitors have suggested that lisinopril, one of the other major ones referred to, doesn't reach its maximum effect until high doses, and the other drug, which was the major contender, ramipril, they were saying in their promotional materials also not as good, and they have a graph towards the end. This is what the judge was referring to in that paragraph.
Yeah.
So that's how Servier deploys this sort of information about the non-interchangeability of its drug on that practical parameter. The other was titration, bumping up the start dose until you get to the right level. And for that, if you go back to the judgment and look at page 129, paragraph 188, see that this also assumed importance in the judge's reasoning. At paragraph 188, he introduces the fact that it's necessary to take into account what he describes as a pharmacokinetic factor concerning titration. He explains what that means: start them on a low dose and gradually lift it.
Yeah.
And if you look at paragraph, he refers to Servier's expert explaining the practical implications at the end of that paragraph. And then in 189, if you look at the first two sentences and the last, the judge concludes that getting the patient to attend the surgery several times would reasonably be seen by the GPs as an inconvenience and cost, and where they're frail or elderly, it could be a burden and so forth, which the GP could legitimately take into account. And finally, in the last sentence, Servier strongly emphasised in its promotional materials to the GPs the advantage of perindopril as needing limited titration steps. I consider it wouldn't have done so if GPs had not perceived this as a benefit. And if I may just focus on that, if we go back to page 91 in the judgment, paragraph 55, you have the reference to the examination of the Servier factual witness. He was the CEO of the UK operating subsidiary, Mr. Falcon.
Sorry, 91.
91. And at the very foot of page 91, in paragraph 55, at the last sentence, you see Mr. Falcon stood by Servier's assertions in its promotional material in the relevant period that for prescribing doctors, there may be a good reason to prefer perindopril based on the ease of titration. And when it came to switching a patient already on perindopril, the burden of the checks involved in switching had to be carefully considered against any possible benefit. And the promotional material to which reference is made, for that we go again to the same underlying document in the supplemental bundle at tab 2. And on page 5, you see again the comparative steps, the comparative reasoning given by Servier as to why clinicians should prefer its drug to the others. So just under the first paragraph, it says on page 5, use of perindopril will encourage more patients to reach the target blood pressure levels because the initiation dose of 4 milligrams is the usual maintenance dose. This is a unique advantage of perindopril. Majority of patients are controlled at that level. There's only one titration step to the maximum dose of 8 milligrams. No cost penalty for using that dose. And both the other drugs, ramipril and lisinopril, require multiple titrations to get to the more effective higher doses and so forth. So this illuminates how the judge saw this and the evidence that he took into account. And we can now go from that directly to the judge's conclusions on issues A and B on page 141, paragraph 230. Sub-paragraph Roman 1 in 230 is dealing with the new initiations in primary care for patients who have uncomplicated hypertension. The judge notes in little a...
Sorry, Mr.
Sorry.
Just give me the
Yes, I'm sorry. It's,
reference.
so it's page 141 in the judgment, paragraph 230, his conclusions on the threshold issues, and there's a series of them in Roman 1 to 5. In Roman 1, he's dealing with uncomplicated hypertension.
Yeah.
And that's what I'm looking at now. In little a,
Yeah.
he says that in the early period, lisinopril was a reasonable alternative, but only at one dosage, which was 20 milligrams, not 40. And that was important for a reason that he picks up in his permission to appeal ruling, which I need to go back to immediately for this point. It is that the comparison here made with lisinopril was not straightforward because an important proportion of the patients only achieve good blood pressure control when they've got the higher dose of 40.
Yeah.
And this is something he notes in the judgment that Servier's expert specifically agrees to. And that's on page 130, a few pages back, at paragraph 191. So on page 130, about 6 lines down, the sentence reads, Professor Brown accepted under cross-examination that a significant proportion of patients on the Synapil would be taking the higher dose, the 40 milligrams. And then the claimants produced a graph showing the impact of this on the price comparison.
Does that mean that if you were contemplating putting a new patient on an ACE inhibitor, you wouldn't know until you tried it whether they needed 20 milligrams or 40 milligrams?
Correct. Yes. Yes. And in the end, it seems to be that most patients are on the 20, but a fraction which the judge describes in his permission to appeal ruling is unknown, and might have been anything short of 50%, end up being on the 40. Yes. So I mentioned that this is a point specifically emphasised by the judge in the permission ruling, responding to Servier's characterisation of his judgment. Just to give you the reference, but I don't propose we go there, it's paragraph 7 in tab 7. Returning to the conclusions of the judge, in paragraph 230 on page 141, we just looked at the new initiations for that condition. Subparagraph Roman 2 refers to switching a patient in primary care who's already being treated with perindopril for the uncomplicated hypertension. And the judge's findings are that this group, and this is an important point, account for the vast majority of all patients with uncomplicated hypertension. It doesn't quite eclipse, but it's far more important than what we've just been looking at. This is long-term patients on repeat prescriptions. And if you go in the judgment to page 152, a few pages ahead, and you look at paragraph 266 first, you'll see there that just before the quote, about 4 lines up, you have the expert for the health services, Dr. Durden, saying it's well recognised about 75% of all prescriptions are repeat, but considered that as ACE inhibitors are prescribed for persistent long-term conditions, the proportion for those drugs is about 95%. And in his first report, Servier's expert, Brown, expressed a similar view. The prevalence of hypertension means in any 1 year, the number of newly diagnosed patients is probably less than 5% of all hypertensive patients on the register. Then, without needing to go into the detail, there's qualifications, and over at the bottom of the page, he refers to an IMS study showing that whereas in the 3 years, 2003 to 5, respectively, nearly 40% of patients on perindopril were new that year. Thereafter, the proportion of new patients sharply declined to 13% in 2008. And a comment made by the judge about that in his permission to appeal ruling is simply to put in perspective that this group of patients, the ones who are the repeat prescription individuals, are much more important, regardless of the precise figure, than the first group that we've looked at in Roman 1, in Roman 1A in paragraph 230. And if you then go back to see what the judge says about the repeat prescription people, 231B on page 141, here, 230 Roman 2.
Roman 2.
Yes, my mistake. There you see the judge entering very significant practical qualifications about the circumstances when it is reasonable or appropriate to switch patients in primary care from perindopril. and these are very individual. The judge found it's not reasonable to do so in any cases where the patients are elderly or frail or otherwise vulnerable because of having other conditions. So to stand back, even for patients with uncomplicated hypertension, which is one of the conditions for which this drug is used, the findings in the judgment were indeed that there were many and varied situations where you couldn't simply regard perindopril as interchangeable as a prescriber with the other drugs. There are, however, a range of other conditions for which the drugs are prescribed, and you've heard that those include heart failure, major adverse cardiac events, heart attacks, and post-stroke treatment. And that those situations accounted for between, it was estimated, 25 to 30% of all prescriptions for this drug. You see that on page 152, at page, for simplicity, 265, paragraph 265, the last sentence, referring to Servier's internal figures, which referred to the figure of other conditions accounting for just under 25%. And on the previous page, he says that that's broadly consistent at the bottom of the page with a crude estimate of about 30%. So 25 to 30%. Now, for all of these other conditions, there was another factor that the judge paid heed to. And you see that if you go to page 170, at paragraph 339. Here he records in the first sentence what I...
Paragraph
339 on page 170. He begins by recording the point that I've just drawn your attention to, that the internal figures of Servier said that about 25% of the prescriptions of perindopril, Coversil's the brand name, weren't for the uncomplicated hypertension, but for the other conditions. And in all these situations, the judge finds that the treatment will probably, as he says, have originated in secondary care, the hospital setting, and the GPs would not reasonably, he explains his finding, would not reasonably change to another drug. So I've sought to draw the strands together, but you see from this in my submission that Servier is quite wrong to submit to this court that the judge's findings in the judgment entail that there were large numbers of patients available simply to be prescribed ACE inhibitors apart from perindopril, on which the health services could train their focus. Indeed, in relation to the majority of the patients who are already receiving perindopril and who would need to be switched over to another drug, the judge specifically drew attention to the very serious practical difficulties standing in the way of both the PCTs and GP practices to not merely patient issues, but logistical, administrative issues for those bodies, which fed into the central issue that he had to grapple with of what was reasonable and accepted good practice on the part of the health authorities. And you see that best if you go to page 176, at paragraphs 358 and 359, under the heading Switching Programs. He records at 358 that the defendant's expert, Ms. Kerr, accepted that getting doctors to switch patients who were stable on the existing medicines was much more challenging. And she refers to how difficult it needed to be and what was required. And that 359, Servier's orientation plan, 2006-7, recognises itself that many PCTs just don't have the infrastructure to be able to carry out any switch programs. And the judge records further in 359 that there's the additional work to be taken into account for the GP practices as well, which features in the question of reasonableness. As the NAO's guidance to prescribing advisors stated, changing patients can incur cost time and money for the clinicians, it's critical to understand this as part of the investment. Therefore, even if the PCT had the resources to implement a programme, switching had to be selected with care, and the number of such programmes could be limited. So this is an aspect of the administrative and logistical burdens and the financial constraints that were there as well. With that, my lord,
There was a financial element that came in at that point as well, wasn't there? Because there was the cost savings from switching on statins was much greater.
That's right. Yes,
than
I haven't gone back to that yet, but yes, absolutely. So what he is saying is
Right,
that
and also I picked up that that's what Servier was saying, and that was part of their deflection strategies, was to say to the health authorities, look, you're not really saving any money by switching from our drug, which is a better drug anyway. Why don't you focus on statins, because you'll save some money that way?
yes, I'll show you that directly. No, that is what the judge found. That is what they did. They also said, why don't you focus on telling people to prescribe ACE inhibitor drugs, of which ours is one, instead of the more expensive ARB drugs for this condition as a general matter, and not concentrate on also advising them to switch to generically available ACE inhibitors. So this is part of the findings. And to stand back, this I hope deals in my submission with the first major mischaracterisation of the judge's findings in the judgment. Next, I'll turn to Servier's characterisation of the judge's findings concerning the key issue, issue C. Did the public health authorities act unreasonably as alleged? This part of his judgment begins at the foot of page 142, paragraph 233. You see the heading, issue C, and what the judge begins with is to set out a number of the key legal principles from the case law which guided his assessment. No complaint is made about the accuracy of any of that, and I wish briefly to draw the court's attention, we've already looked at this to an extent, just to 2 points of principle which overlap, which are especially relevant to this appeal. On page 143, you have the centrally important extract from Lord Nichols' judgment in the House of Lords in Kuwait Airways. And we've seen that in it, Lord Nichols articulates the principle that the question is whether the plaintiff's harm or loss should be within the scope of the defendant's liability, given the reasons why the law has recognised the cause of action in question. That's in paragraph 70 in the quotation from Lord Nichols, about 8 lines down.
Yeah.
And Lord Nichols also says at the start of that paragraph, paragraph 70 of his opinion, that this exercise involves reaching a value judgment. And he continues in paragraph 71 at the foot of the page by stating that in most cases, how far the responsibility of the defendant ought fairly to extend evokes an immediate intuitive response. This is informed common sense by another name. Now, pausing there, Mr. Justice Roth expanded on what this principle entails in the specific context of competition law claims such as the present. And he does that at the foot of page 145, 2 pages further on, in paragraphs 242 and 243. So he's now applying Lord Nichols to this context, and he states at the start of 242, at the bottom of the page, that the purpose of this legislation is to protect consumers and the economy generally from artificially high prices resulting from anti-competitive behaviour. If you turn the page to 243, paragraph 243, as the judge makes clear, in this context, it is the public health authorities which are the consumer. And this is the context in which one comes to consider the drug company's present allegation, which is that the authorities who paid for its product high prices for its product, acted unreasonably in doing just that. In other words, in being consumers, because they should have made greater efforts to persuade doctors to select other products. And you'll see that the judge at the top of this page, in paragraph 242, is making a second point, that the competition legislation has a complementary purpose as well. He records that private actions for damages for compensation under the legislation play an important role in strengthening the working of the competition rules and discouraging anti-competitive agreements. The implication here is that it's important for the courts not to allow that purpose to be undermined in the context of assessing Servier's complaints of an unreasonable failure by the public health authorities to take action. Now, this proposition is in substance, in my submission, aligned with the observation that was made in the Stellantis case by Lord Justice Green last year.
It's the same point. It's
Yes,
just another way of putting the same point.
yes,
In a different context, of course, because the mitigation issue arose in a different context to the one in the present case. But the policy issue that lies behind the statement is identical.
I accept that. I accept that it was a different context, and my submission is that it is the same fundamental principle at play.
There's a public policy issue there, isn't there?
Yes. So that's the first general principle that one takes from the case law that's recited. The second, the overlapping point, is what emerges from what the judge says first in paragraph 237 on page 144, where he's focusing on the Banco de Portugal case and the opinion of Lord Macmillan, 1932. And he's referring to this for the principle that the measures which a claimant may be driven to in order to extricate themselves from the consequences of wrongdoing ought not to be weighed in nice scales at the instance of the party whose breach has occasioned the difficulty. And in amplification of that second principle, the judge goes on in the two following paragraphs, 238 and 239, to quote from the judgments of Mr. Justice Leggett, as he then was, in Thai Airways, and Lord Justice Gross in Borealis. And the point to be derived from those authorities is, to cite Mr. Justice Leggett, that the standard of reasonableness is applied with some tenderness towards the claimant, having regard to the fact its predicament has been caused by the defendant's wrongdoing. And similarly, at the top of page 145, it's Lord Justice Gross, in that case, commenting it wouldn't be right to be unduly precise in assessing every step taken by the claimant in that case in dealing with the consequences of the supply of contaminated butane. So those are the essential general principles of the law which were applied by the judge in this case.
Can I just ask, how do you say those principles relate to each other?
I say that they overlap, they converge.
So
Because
do you mean there is an independent principle, regardless of whether or not reasonableness comes into it, and you take account of being tender to the defendant? As a matter of public policy, you don't allow, in the competition law context, someone to advance this sort of argument? I mean, how does it fit together?
yes, I'm obliged. I would put it this way. Perhaps the starting point, and maybe I should have presented it in this fashion, is the Mr. Justice Leggett point, Banco de Portugal point, that when one is generally dealing with this sort of defence of failure to mitigate, for the general reasons that those judges give, it's not appropriate to weigh in nice scales the behaviour of the claimant, and attempts by a defendant to do that will be repelled by the court. The principle that Lord Nichols then articulates in Kuwait Airways is a more specific point, that one must pay attention to the context in which the particular plea of failure to mitigate arises to determine further to what extent such a plea should be allowed to be advanced. And in the specific context of competition law claims, where one is faced with what is an arm of public policy and the protection of the consumer. Here, where the consumer is the public health authorities, to say that they should not have been a consumer because they should have taken other steps is a matter that the court should be sceptical about accepting. So I take it no further than that, but that in a nutshell I think is how I would say that the two principles coalesce. Now the major part...
Just before you move on.
Yes.
By way, going off to tangent in a way, I mean, an additional factor in this sort of situation is that the money that it's said that you needn't have spent went to the claimant, went to the defendant. I mean, very often when you're dealing with failure to mitigate, it said you spent too much in one way or another. But that's not in circumstances where you spent too much on the defendant. Whereas here, it said that you spent too much on the defendant's products.
So
Yes.
the classic breach of contract case is because, for example, the defendant hasn't delivered the goods and the claimant's gone elsewhere. And the allegation is you spent too much on buying it from somebody else, but that's not this situation, as my lord says.
My lord, that is right, and we did advance that point. I'll find the
They're
reference.
seeking to profit from their own wrongdoing.
We said that that was a point that should be taken into account. It was not a point that was accepted by the judge.
Paragraph 244 of the judgment.
Thank you.
244, is it?
Yes.
Oh, yes,
I'm
yes,
obliged.
It's the sole.
That's right. So we did make that point,
Yeah.
and the judge did not. He did not agree with that point.
The judge did have some sympathy for the idea that it's curious that where Servier have spent a lot of efforts to persuade you that their product is better than isn't interchangeable, because there are advantages, both clinical and non-clinical advantages. It's then very curious that they come along and are able to come along and say, but you should have ignored what we were telling you. You should have switched anyway.
My lord, that is so.
As I read it, it's not a sort of blanket legal defence, but it means that the level at which you identified that claimants have behaved unreasonably is an elevated one.
That's right. The judge, in fact, did not merely express this as a matter of curiosity. He did, and I'll take you to the references in a moment, express himself in trenchant terms that this was a highly important consideration when one is assessing the standard of reasonableness. And it's a matter that he returns to in the operative paragraph of the judgment on which scrutiny is now brought to bear, paragraph 391.
Yeah.
And he returns to it again in his permission to appeal ruling.
And that's an application of Lord Nichols's statement that when you're looking not at the factual question, but at what you ought to be liable for, there's a normative element, a value judgment as to what the reaction of the court is to these circumstances.
Yes, it's a reference, in a sense I pick up the reference to the informed common sense, which is the phrase used by Lord Nichols, and it is a normative judgment applying again how he approached matters in Kuwait Airways, and the judge deploys that in his reasoning in this judgment. Now what has been said on the other side in their opening address is that the judge did refer to this, but it was one among a host of considerations, and therefore was not to be given weight. My submission is that a proper reading of this judgment shows that although the judge did not treat this as a single knockout blow, he treated it in the way that your lordship has just described as a highly important consideration which elevates the standard. Now,
Yeah. I mean, striking in that context of picking up my lord's point, that Mr. Falkland actually stuck to what was said in the promotional material, and that continued to maintain that Perindopril was better than anything else.
yes,
And also there's a point which think it was in paragraph 188 that the judge makes the point, well, they wouldn't have done any of this if it wasn't actually having some appreciable effect. In other words, the doctors were convinced by what it was that Servier was telling them.
Yes. Yes, and
One of the points that Mr. Saunders made yesterday when I asked him about this was, oh, well, this is all, and I paraphrase, I'm not intending to be offensive, this is all just sort of puff, promotional material, and may not have been people selling brushes from the back of a van as he accepted, but it wasn't, it was something that the doctors could, they would be sceptical about it, etc. And I just wonder whether that's really what was happening in the real world. I rather doubt it somehow.
yes, there are a number of points to be made. First, it was contrary to their case under the first limb, which is interchangeability.
Yeah.
It was directly contrary to what they have pleaded. Second, it was something which the judge finds in terms, and we'll come to the precise paragraphs where he does so, is something that is not merely curious, but is something that should not lie in the mouth of a defendant in this position, which is making strenuous efforts to stop the victim of anti-competitive behaviour from moving to other drugs, and to say that they should indeed have done that as a normative matter, regardless of the extent to which one focuses on precise causative potency. To what extent did this actually have an effect?
Yeah.
It's a normative value judgment about that form of behaviour in this litigation context.
Yeah.
Now, the major part of Mr. Justice Roth's judgment on issue C extends from paragraph 269 on page 153 all the way through to his ultimate conclusion at paragraph 386 on page 182. So there are over 115 paragraphs in which the judge systematically considers each of Servier's specific pleaded allegations of unreasonableness on the part of the health services, and he finds them one by one to be without substance. In the appeal before your lordships, Servier vaults over all of that as if it was not somehow the gravamen of the trial heard by the judge. Its focus is trained purely on the final 3 paragraphs of Mr. Justice Roth's judgment, in which the judge addresses for good measure the unpleaded suggestion by Servier that it's not possible to determine the issue whether individual trusts acted unreasonably unless you investigate their individual situations. And the crux of the judge's response is focused in the final paragraph 391 on page 184, to which I ask the court to turn. In the preceding paragraph 390, he has just recalled in brief terms the principle articulated by Lord Nichols, and he has cited Stellantis for the proposition that the court must be careful not to allow the manner of applying procedural and evidential rules to make vindication of a right to onerous. And then in paragraph 391, the judge reasons that in all the circumstances of the present case, as to where the bar should be set, it's necessary for Servier to show that the health services failed unreasonably to observe clear standards in the provision of medicines management which applied at the time. And that, in my submission, is the critical point raised by his decision. In other words, it is not appropriate for Servier to say that the procedural and evidential rules of court entitle it to call for disclosure or information in the circumstances of this case to enable it to carry out a minute inspection of how each local health authority in the 4 nations made its individual decisions from year to year, weighing their competing priorities. He sets the level by reference to the considerations that we have examined as being that Servier must be in a position to say that the health authorities disregarded some clear general standard in the field. For example, how one goes about constructing a local formulary, which was accepted good practice at the time. In this paragraph 391, the judge goes on to identify key findings of fact that he had made, which contribute powerfully to his conclusion about the need for Servier to demonstrate this. If you read from the third line in paragraph 391, the first of those is Servier's efforts not only to persuade clinicians to prescribe Perindopril, but to forestall any initiatives to dissuade them. And as to the promotional efforts made by Servier, the point is the company not only took steps to keep the price of the drug artificially high, it took steps through a multiplicity of means to persuade clinicians that its drug was the drug of choice for their prescribing needs. I will not rehearse it in detail. We've already seen the evidence given at the trial by the former CEO of the UK operating subsidiary, Mr. Falcon. The central part of the judge's findings about Servier's behaviour, to which he's referring back in this paragraph, can be seen on page 117 and following in the judgment. This is the promotional efforts. Go to page 149. I'm sorry, 117. My mistake. 117. And you have there paragraphs 149 and following, which is the extensive section in which the judge lays out the promotional claims that were made by the company. And what he finds is that it exerted influence through a highly resourced and sophisticated national sales force, and the judge makes trenchant findings about the effectiveness of that activity. If you go to page 121, at paragraphs 163 and 164 in particular. My lord, this may at 163 be the point you were referring to, or at least a similar point, because he says in 163 at the beginning, at the end of the day, as both those two experts pointed out, sophisticated pharma companies like Servier would not spend such a large budget on medical reps and drug promotion to GPs if it was not effective. The fact Servier did so with regard to Coversil over this period is, in my judgment, very significant and more powerful evidence than any individual survey. If you go to the end of that paragraph 163, he refers to the evidence given by Servier's expert, Professor Brown, about the effect on specialists of Servier's messages about Perindopril based on one of their major studies, Europa. At this time, 2003, do you consider messaging about the special qualities of Perindopril was capable of producing an impact on the specialists? My lord, the simple answer is yes. And then at 164, you see the reference to that particular evidence study, the Europa study, being described by Servier in its internal documents as to its effects. So in the quotation, you see from the second line, Europa has successfully been used as the main proof of efficacy, and the campaigns differentiated their drug Coversil from the other drugs. And the comment in that paragraph towards the end is that it had led to a massive increase in market share at a hospital level, especially cardiology, which has helped drive increased use in primary care, with which we are now concerned. The targeting strategy we've pursued has successfully increased the depth of the Coversil prescriptions, and so forth. So you see there the explanation of how Servier is explaining internally how it harnesses the results of medical studies to distinguish its product in the eyes of the prescribers. If you go to page 123, 2 pages on, paragraph 167, he then makes a finding about a further aspect of the promotional activities, which feeds into his conclusions. At paragraph 167, he refers to Servier's approach of picking consultants and academics who favour the use of perindopril. Internally, they're called key opinion leaders, or KOLs, to act as product advocates for Servier's drug, and it would give them sponsorship and fund their expenses. I won't go into it in detail, but your lordships will see that all these findings about Servier's contemporaneous behaviour are in direct collision with the pleaded case, namely that the health services knew or ought to have known that there was simply no difference between perindopril and the alternative medicines. That is their plea. Here, therefore, in my submission, we are squarely in the realm of what Lord Nichols described as informed common sense. And to pick up my Lord Justice Nugee's remark about this, the judge does draw attention to what is a striking incongruity in another part of his judgment, and for that you go to page 96, paragraphs 63 to 64. It's true that he begins, and perhaps, my lord, this is where you picked up the reference to curiosity. In the beginning of 63 on page 95, he talks about a curious feature of the trial. However, he then warms up in how he reasons. If you go to the top of page 96, his findings are as follows, 3 lines down. The prescribing argument, in essence, amounts to the contention by Servier that the claimant should have avoided the loss by encouraging clinicians not to prescribe its own product, which Servier was actively seeking to promote to those clinicians at the time. The causation remoteness argument goes even further. It contends the failure by the claimants to take the various alleged steps to discourage clinicians was the sole effective cause of the claimant's loss. A disinterested observer might find it surprising that such arguments would or could be advanced by a defendant found to have committed a very serious infringement of competition law. And then he goes on to refer to the fact that Servier was in the position of having to disavow in these proceedings some of the claims it made to doctors at the time for perindopril, and which its own expert variously described, some of them as not remotely justified, fake science and misleading. Moreover, Servier subjected, this is the stroke consultant, we'll come back to him in a few minutes, Dr. Smithard, a senior consultant who firmly believed in the advantage of perindopril, to strong cross-examination suggesting his views were mistaken. Indeed, Servier's closing submissions accused him of having quite extraordinary ignorance. So in short, the judge was right to allude to these findings about Servier's promotional activities, paragraph 391, the paragraph of interest.
In fact, he being one of their key opinion leaders.
Yes, this was one of their key opinion leaders. Yeah. In assessing in what circumstances it would be fair or just or reasonable to reduce the compensation due from Servier to the health authorities. But the matter doesn't end there. So that's the promotional side.
Is it a convenient moment to take a break?
I'm sorry, it is. It is.
To the next point, if that's a convenient point.
Yes, it is.
5 minutes.
You'll still be absolutely.
I love the window because we're getting a print off with highlighted versions.
No.
slightly reminds me of do you remember once with The Economist on National Grid, you were still looking on the children at the time, and you turned to him now this Klein is Klein, that's the engineer.
No, you know the reason why I did that? It's not something that needs to go to the proposal individual, but just the generally he had this habit of speaking to people of conferences and that was not you. I just, as a 25-year-old, this is what a living citizen.
Yes, that's right. Solicitors.
You have to ask whether people need the toilet. You realise that.
Yes. It's useful for the
Idiosyncrasy.
diversity section of the application form.
So we're dealing with so after this is severe submissions, then it does go quite
Interesting that
Yes. Which is not, of course, rejected.
good measure of rejected by anything as well. It's got a long pedigree of getting rejected by people.
Nearly done, John?
sorry.
Nearly done.
That's more.
Saving me my hour. Look, saving me my hour.
What is it? You hour. My Lords, I was addressing the findings on Servier's promotional behaviour to distinguish its product from others in the class and the implications that the judge drew from that when considering the reasonableness issue. There was a further point, as I say. In paragraph 391 of the judgment, the judge refers not only to the promotional activities, but materially to the efforts to forestall initiatives by the health services to steer prescribers away from perindopril.
Yeah.
And this is a separate conceptual issue. One is saying that irrespective of the benefits of our drug, perindopril, here are some reasons why you should focus on doing other things as a matter of your priorities. Those sorts of submissions made to the health authorities themselves. There are two earlier parts of the judgment which bear on this point. First, you go to page 163, foot of the page, in paragraph 315, Roman 6. And you see at the foot of the page, Roman 6, Servier had the point about made above about how pharmaceutical advisors may interact with local consultants who support the inclusion or retention of perindopril, and say it was very alert to the threat to remove or demote perindopril from local formularies and developed a strategy to mobilise support from the local cardiologists to counter this threat. Thus, an internal Servier document produced following the price reductions for generic Ramipril and lisinopril included a spreadsheet listing 403 trusts and boards, colour-coded to reflect the estimated degree of risk to Servier's business, and then set out a series of bullet points setting out the steps which the reps should take, including a series of matters which are then listed. And if you go to page 165, I won't go to those in detail, you read the final part of this paragraph 315, beginning under the quote, of course, Servier's efforts were not necessarily successful, but I don't accept the submission made for Servier that what it did at the time is irrelevant to the question before the court. In my judgment, in the context of this case, such a strategy on Servier's part is very material to the determination of whether a PCT or board was acting unreasonably in failing to mitigate its loss recoverable from Servier because it didn't decide to mark perindopril as a second line or less preferable choice of drug on its formulary. So he's there drawing attention to the fact that this is not a consideration among many, it is an important consideration. The other reference is paragraph 362, which we've already looked at to an extent on page 177. And this paragraph specifically refers to initiatives by local health services to introduce schemes to incentivise prescribers in their area to select drugs other than perindopril. And you see that Servier put in place, 4 lines down, what it refers to as strategies for negating PCTs that are focusing on a switch, or 10 lines down, deflection strategies. These are intended to urge the health services that they should be prioritising other matters when managing their budgets.
Sorry, I must be looking in the wrong place. Which paragraph should I be in?
I apologise, this is 362
Yes.
on page 177.
Yes, I see.
4 lines down is the reference to the negating PCTs.
Yes.
And then further down, about 10 lines down to the right, deflection strategies.
Yes.
And these are the ones that my Lord the Chancellor was referring to earlier, pointing out the significantly greater savings from switching among statins or away from ARBs.
Yeah.
And further, the emphasis placed on the GP workload that the switching programme imposes.
And that's in that document you showed us at tab
Which,
2.
if we go to that briefly, you will see it directly. It's supplemental 2, supplemental tab 2. And I'll only take you to certain references. The entire document is concerned with this. At page 8, in that supplemental document tab 2, page 8, you see the heading towards the bottom, deflection strategies. And over the page, GP workload. And I invite you to perhaps read what's said under GP workload. This could potentially be a big argument in our favour in any area which recommends switching patients from Coversil onto other drugs, especially considering the pressures most GPs are under at the moment. And the series of the arguments that they were deploying, you see after the bullet points, the workload argument is best used with the individual GPs and at the least should delay things happening, if not stopping it entirely. Also the ethical argument of switching controlled patients. So the judge's conclusion we put this away, is succinctly summarised in paragraph 363 of his judgment on page 177. He says there, shouldn't necessarily have been, the PCT shouldn't necessarily have been influenced by such efforts, but in my judgment, then you have the value judgment, when assessing what the claimant should have done to mitigate the damages they can claim from Servier as the result of its anti-competitive conduct, the claimants were not reasonably required to do precisely what Servier made sustained and calculated efforts to dissuade them from doing. So that is the application of the normative value judgment. It is not merely an issue of factual causation.
That's specifically in the context of switching programs, isn't it?
That is, yes. And you may see, perhaps refer to this again, at the end of 362 above.
Yeah.
He refers to one of their strategies, which was to advocate to the public health authorities in 2006, when a generic version of perindopril had temporarily appeared on the market, that it's expected that there will be increased generic availability within the UK in the near future. In other words, don't take action
Don't
now.
switch yet.
Don't switch yet, yes. So finally, that's the actions of the defendant. In paragraph 391, page 184, on the question of what's just or fair or reasonable, the judge also draws attention to the perspective of the health services themselves. And in that paragraph, he also refers to his finding that there was an evolving approach of medicines management to promote more cost-effective prescribing. So the situation is fluid. There were not established general standards in the field. And for that proposition, to explain his finding, we go back to page 172, and you see this at paragraphs 344 and 345, which I shan't read in detail, but you see he describes this in 344 as a fourth general consideration, being the internal organisation and structure of the trusts in the NHS. And he makes clear that medicines management was a recent development and it was evolving. There's great diversity, there's no clear standards, and at 345 he also makes the point that the reduction of the PCTs in number from 303 to 152 caused particular disruption, and that accordingly delayed the establishment of new initiatives in the reformed PCTs. So he's there giving a picture on the, what I may call the demand side, of how the consumer, the health authorities are themselves under a certain degree of stress and pressures, and what can be expected of them needs to take that into account too. And in that regard, the final point on the, as I call it, the demand side, is the obvious point that the health services are not, of course, dealing with perindopril alone, as one might think when you look at the pleading. What is obviously happening is that they are taking account of a multiplicity of national and local considerations. They're weighing priorities within the limits of their resources. And earlier in his judgment, Mr. Justice Roth was emphatic that the issue of priorities was highly material again to the question now before him at the trial. And he puts this most clearly at page 167, starting at paragraph 329, and you'll see there at 330 he refers to the agreement between the experts that everybody had multiple competing priorities. At 331 he comments that the point about competing priorities was a theme of virtually all the factual evidence from those who worked in medicines management or as pharmaceutical advisors. And if you go over the page, my lord, at paragraph 333, he lists in those Roman numeral subparagraphs the different priorities that generally were more important than the level of prescribing of this particular form of ACE inhibitor, perindopril. And ARBs is specifically dealt with at Roman 5. So my point here is that Servier's pleaded case on failure to mitigate is two-dimensional because it didn't recognise the health service's many other competing priorities, refers only to perindopril in isolation, and yet its own deflection strategies, to use its term, those were designed to convince the health services to prioritise other matters. And as I've said, at the end of paragraph 362 of the judgment in particular, the judge specifically highlights the audacious strategy of suggesting to PCTs that they should wait before doing anything because generic versions of its own drug, perindopril, were on the horizon. The implication of this for what the court was considering about the standard to be observed, the standard of reasonableness that should be applied in a failure to mitigate defence is this: to delve into individual health authorities' management of their priorities would open up a vast new front in the litigation, which the judge was not prepared to countenance, and we say rightly. In the second sentence of paragraph 390, he makes a point that he made at the trial. Says he observed at the outset that this trial was not a general inquiry into the operation of medicines management in the NHS in the 4 nations over the relevant period. And in sum, all of this feeds into the judge's conclusion in paragraph 391 that the failure to mitigate defence would necessitate Servier showing an unreasonable failure on the part of the health services, if it was legitimate, to observe clear standards which applied at the time. So, my Lord, that is my description of the findings of the judge on the second issue in the judgment. I turn then to Servier's submissions on ground 1. Because against the context that I've set out, I hope that I can dispose of those submissions reasonably briefly. The first point is that Servier argues that its pleaded case about what was accepted good practice for all health authorities, as you've heard, encompassed an unpleaded argument that individual PCTs should have taken some steps and that it all depended on local circumstances. I've already adumbrated why, in my submission, that does not follow at all. And I put it in these terms: the unpleaded argument does not depend on investigating the same set of considerations as are relied on to support the pleaded case. The unpleaded argument depends on the need for a deep dive into the local circumstances and priorities of individual trusts, which Servier itself has consistently maintained are extremely varied. The question then becomes, if you go down that route, given the local circumstances and priorities in a particular area, has this body behaved competently? And what you have is a series of micro-investigations of hundreds of individual cases, and that is altogether different in nature from the pleaded case, which raises other issues. It is, in my submission, intricate and intractable. Second, Servier alleges that unanimous expert evidence was that all the PCTs should have taken at least some steps to encourage prescribing of generic lisinopril or ramipril for new patients. That's in its skeleton at paragraph 54. The main point here is the proposition that the PCTs should have included, or tried to have included, on their local formularies where they had them, a generic ACE inhibitor as the preferred choice. So this was an unpleaded contention that was advanced at the trial. In the judgment, the judge introduces it at paragraph 314 on page 162. If you would please turn to that. Page 162, paragraph 314. Servier also advanced at trial an alternative and lesser contention that local formularies should have contained an indication that one or more ACE inhibitors which were available generically were the preferred option.
Sorry, I haven't got the paragraph.
My mistake. Page 162, paragraph 314.
Yeah.
The proposition which was advanced at the trial is referred to by the judge at 314. In the following paragraph 315, which extends over a number of pages, he systematically sets out a series of cogent reasons why that is not well founded. So very briefly, Roman 1, many authorities didn't have formularies and the standards for them were developing. Roman 2, to set a preference between the drugs imposes a significant additional burden. Roman 3, it was reasonable to expect perindopril to have come off patent shortly and come down in price. Skip ahead, Roman 5, if local consultants supported perindopril, then it wasn't unreasonable to follow their advice. And that's an important point which we'll be returning to. You see that in Roman 5 towards the end of that subparagraph. And Roman 6, that Servier, we've seen this, took measures to counter such initiatives. So that's the first part of the claim in Servier's skeleton argument. The second part of the suggestion that there was unanimous expert evidence at the trial concerns supposed ease of health authorities to just communicate to local prescribers that their first choice ACE inhibitor should be, for example, ramipril for new initiations. This is paragraph 38b of Servier's skeleton. The suggestion is that there was a unanimity among the experts, and that is not correct. It's certainly not correct to imply that the health services expert, Professor Chapman, opined that health authorities should reasonably have sent out those forms of communication. The judge records that the theme of the health services expert's evidence was consistently about the importance of weighing the multiple priorities in the practical context of having limited resources and it being an evolving discipline. I'll give you two references. Page 95, paragraph 62. If you read there, from she lacked the overview, this is the expert on behalf of Servier brought by Professor Chapman, down to pointing out that what could be reasonably done would depend on the variety of factors. You see the nature of the evidence that was given on behalf of the health services. The other reference is on page 179, the judgment, paragraph 370. And if you read from 8 lines down on that page, some PCTs and health boards considered it appropriate and important to take steps to encourage or reward prescribing of other ACE inhibitors at certain times during the relevant period, but choices had to be made and others saw their priorities elsewhere, possibly because of the influence of local consultants or a belief that the entry of generic perindopril wasn't far off. That reasoning applies also to those PCTs with higher than average levels of perindopril prescribing. In exactly the same way, as Professor Chapman put it, you may recognise there's an area of particularly aberrant prescribing. You may not choose to direct your resources to that because there are greater gains elsewhere. And finally, leaving the judgment, in its skeleton argument, Servier refers to part of the transcript of the cross-examination, and you see, of our expert. You see that if you pick up the supplemental bundle, looking at tab 17. You have the bottom left quartile, page 38. At lines 6 to 10, you have what the judge asks. This was a hot tub. Thinking then first about new patients, should that have been, in your view, one of the priorities for PCTs and boards, to initiate a new patient if they're to be on an ACE inhibitor, it shouldn't be perindopril? The expert for Servier says yes. And then from line 17, Professor Chapman, I would agree, my lord, with a caveat, and it's this. It's a bit like I described previously about omeprazole. A lot of ACE inhibitors were available generically and would have been written by generic names. The change would happen automatically. Should it be a priority to concentrate on new patients for one of the less used inhibitors? I don't believe it would, compared to the priorities you'd have to put into statins, proton pump inhibitors, and so forth. We had bigger fish to fry. And then again, you have the part that's referred to by Servier on that page, where their expert from line 6 says this should be done for a new initiation. Professor Chapman says at line 14, I'm not disagreeing. I think I would rather put it, as we did in our prescribing reports, initiate a generic ACE inhibitor, and that would do it. The judge then continues, and if you go to after the part relied on by Servier and turn over the page, look at the bottom left quartile. The theme is picked up again by the judge, starting at line 16 on page 78. If we go down from the Strategic Health Authority, the regional body, to the PCT or the equivalent in the other nations, Professor Chapman, you're saying it's a question of priorities and there will be great differences one PCT to another. Yes, what are the sort of local factors that are going to influence priorities? Huge number of amount of factors, some of which are logical, some of which, frankly, we don't know. And you'll see that he then goes on to talk about the sheer opacity of trying to get at this sort of information. The sort of things to look at are demography, age, sex, ethnicity. Then you have variations in GP practices. Then you have variations in the burdens of diseases. That's for a start. And he says 40% is the idiosyncrasy of the individual GP. So,
John, can you take us back to the context? This is different. This is about a different point.
well, leave you to do that in reply. My friend says this is about a different point. My submission is that here he's talking about priorities generally and how this applies when one is considering the actions that the PCT should take.
What did the judge find in his judgment about this part of the evidence? Anything that we need to look at, we haven't looked at already?
Not that we haven't, it's really, I had a few more references, but the two that I've already given you,
So 62 and 370.
and 370 are the main ones. I can give a couple of others, but I thought in view of the time I would give those two alone. But as the judge...
Professor Chapman seems to me at least to be dealing directly there with the issue of priorities and saying, well, you might very well not switch to a generic for a variety of reasons because you're actually focusing on other things, or as he puts it in that bit of evidence he showed us, we have bigger fish to fry.
He says that...
Given that Servier was trying to persuade them to do exactly that and focus on statins rather than
on statins and ARBs and on waiting.
Inhibitors, you can see why the judge concluded that Professor Chapman's view was entirely reasonable. End of 370.
Yes, and the other reference is the one that I gave earlier, which is from 330 and 331, where the judge says the point about competing priorities was a theme of virtually all the factual evidence. There are really 2 points. There is that this multifactorial consideration is something that weighs on the judge when he is assessing at what level the bar should be set for the defence of failure to mitigate. There's also the point that one sees from the end of the part of the evidence that I've read from Professor Chapman, that one is really going into some very obscure and difficult matters to try to work out how in a local area the particular authority is having to grapple with idiosyncrasies of doctors, matters that are going to be extremely difficult and, to investigate on a general level. So that is the second argument of Servier. The third is that Servier says that the judge was wrong to regard Servier's unpleaded alternative case as too vague or onerous because mitigation is always a fact-sensitive inquiry. That's paragraph 56. And our response is this. It is not the question of mitigation being essentially fact-sensitive that is the issue here. It is. The issue is that Servier wishes to open up litigation, a litigation front, in which the parties descend into a granular consideration of whether particular inaction in a particular year, in a particular manner, was justified or not, by reference to the resources, local circumstances, priorities and pressures in a particular area. And that involves, in my submission, an attempt to be, as Lord Justice Gross put it in Borealis, unduly precise in assessing every step. The fourth point that Servier makes in its skeleton is that the judge...
I mean, it's an interesting point, isn't it, that if what you're engaging in is that sort of level of granular analysis as to what happened in a particular locality. So you say you pick, I don't know, let's say you pick the health authority for South Devon or something, where there are a lot of elderly people who live by the seaside. You could look at that on, and you get, you might get a overall result there that was actually different from, say, taking, I don't know, Scarborough or Blackpool or something, another seaside area where there might also be other elderly people, but the demographic is very slightly different. And you can see how actually, once you start thinking about this, that the sampling exercise is going to be really totally impossible.
Well, interestingly, my lord, that comes directly back to what the then Chancellor, Sir Geoffrey Voss, said at the first hearing where this matter was considered, in the paragraph I referred you to in December 2016, which is that there is such variety and heterogeneity that one can see.
Perceptive as well.
Yes. The fourth point made by Servier is that the judge was wrong to refer to Stellantis in paragraph 390 of his judgment, and subject to your lordship's views, I shall not address that any further. I think that's sufficiently dealt with. But one aspect of its point that remains is that Servier refers to the arguments that it made in the trial about the illustrative examples that were put forward on part of the health services of how people behaved in certain local areas, Plymouth, PCT in particular, and Rhondda Cynon Taf in Wales, the health board, on the other side. Those were put up by the health services as illustrative examples for the reason that I showed you in the exchange with the judge in January 2018 as to how they were to be used. They were there to show how the system worked. They were not there on the basis that their specific behaviour was, as it were, on trial and would be the subject of judicial findings. And so the judge concluded in his PTR ruling. The nature of the contentions that were advanced by Servier, however, about those local authorities at the trial was essentially to criticise them for essentially negligence or incompetence. And I'll take them briefly in turn. As respects the Welsh board, Rhondda, the contention was that it had incentive schemes which operated in 2005 and 2006, which encouraged the prescribing of ACE inhibitors instead of the more expensive class called ARBs. And that the board should have gone further It should have encouraged generically available ACE inhibitors, and thereby knocked out perindopril. The judge did deal with that issue in general terms in his judgment. And to remind the court what these ARBs are, you see a description on page 168 of the judgment in paragraph 333 Roman 5.
Yeah.
And that's at the bottom of the page on page 168. These are newer drugs for the treatment of the renin-angiotensin system. They're expensive, and the cost is often significantly more than for the ACE inhibitor drugs. Now, the judge considers the question whether medicines management teams could reasonably have considered that reducing the level of the ARB prescribing was a greater priority than reducing prescriptions for perindopril within the ACE inhibitor class. And his conclusions are on page 170 in paragraph 339. And you see he says succinctly, about 6 lines down, in my view, the figures set out above show that a medicines management team could very reasonably have considered that reducing the level of ARB prescribing was a greater priority than reducing prescriptions for perindopril in the relevant period. He goes on in the next paragraph to say that Servier was alive to that point and that part of its deflection strategy is to suggest to advisors, concentrate on the ARBs instead, don't be concerned with our drug. At paragraphs 341 and 342, the following paragraphs, the judge then specifically rejects Servier's contention that any trusts or boards were reasonably required to take the measures contended for by Servier. You see that at 342 very clearly. And finally, if you go to page 180, look at paragraph 375, you have at paragraph 375 a part of the explanation for what was done at Rhondda Cynon Taf. It was given by the head of the medicines management team there, Dr. Hawkins, but he's only identified by the judge as the head of a medicines management at a Welsh local health board. That was the board in question. And I invite you to read what he said when he was cross-examined, because the judge extracts his evidence. You have a finite resource, you have priorities, and he says halfway down, yes, you would have made the savings sooner. It may well have come at a cost of either a qualitative or a safety issue, or potentially even cost savings in another area, because you have to prioritize what you think is the most important thing to do. It was a very eloquent encapsulation by a witness in the industry of the priorities point. And it's a similar story for Plymouth. That's the Rhondda case. The gist of the complaint by Servier, advanced trial, is that there was no good reason in Plymouth for the authority to have waited until 2006 to put in place an incentive scheme about discouraging the use of perindopril, because it could equally have done that in 2004 or 2005 in view of its local circumstances. And Servier claimed, in its words, it was incompetence that prevented it from doing so. The reference, I don't need to go there for it, is in the supplemental bundle, tab 21, its closings, paragraph 216 on page 342. My point is that this is precisely the sort of weighing in nice scales which the judge found to be inappropriate. It was, by the way, thoroughly misguided too, because the evidence at trial had shown there were a number of specific, legitimate considerations that affected what Plymouth did and when. And to deal with those very shortly, at paragraph 315 on page 163 of the judgment, at Roman 5, foot of the page, the judge refers to Plymouth, you see in the last line. Plymouth was a case where what that trust did was that it follows the advice of the local consultants in the field in 2002, the year before the relevant period, concerning the need to keep perindopril as a first-line drug on its formulary. The witnesses' evidence was that that attitude of the local consultants, they believed, continued. So this is a good illustration, again, of the sort of intractable granular detail which Servier is now proposing to this court should form part of a resurrected mitigation defence. The second point on Plymouth is that the witness from Plymouth, Miss Watson, referred to reliance on information about drugs coming off patent, which she had looked at, in a publication called Prescribing Outlook. And that publication suggested that a generic form of perindopril was on the horizon. The judge found that it was reasonable for a trust such as Plymouth to rely on the information in that publication for measures it took in 2005. And you see that in paragraph 315, you have that open in front of you still, at page page 163 still, 4 lines down in Roman 3.
Roman 3, yeah.
Yes. So in summary, we say that Servier is wrong to allege that it has any solid grounds to say that there has been an unreasonable failure to mitigate in the circumstances of the present case. And this is why the judge's decision should be upheld. Servier is driven to make fine-grained accusations of incompetence on a PCT by PCT basis. And the specific examples it gives are not only wrong, they are misguided because they demonstrate, in fact, the unworkability of the very exercise that they have in mind and the inappropriateness of descending into this level within the broader context of Servier's own general marketing activities and its attempts to negate change. So, my lord, there is only one more argument that Servier raises in relation to ground 1 as I apprehend it, and I'll deal with that shortly. The final argument is that if the claimants were just a single trust, that undoubtedly they would then have the right to call for all the internal documents showing what that trust did and didn't do and the reasons why. So it says in those circumstances, we would be enabled to go into this issue, and we should not be prejudiced by reason of the fact that there were several hundred rather than merely one.
Yeah.
There are 2 points to make. The first is the response taken by the trial judge in his consequentials ruling. At tab 7, he gives it on page 188 at paragraph 13. And the judge's response is that irrespective of how such a hypothetical case might have been conducted, it can't be equated with the present claims, which in England alone involve 303 PCTs for the earlier years and 152 for the later years. And he says the decision to order preliminary issues to establish general standards was taken as means of proportionate case management, but the court advocated by Servier would fly in the face of the overriding objective. He refers again to Stellantis. Mm-hmm. So we endorse that in our submissions. The context of the present case is that you do have a consolidated claim by the English NHS authorities, and that in this type of situation, where you have these significant differences between the local circumstances of all the local health authorities, where the court has found that a sampling approach is not workable, the demands of Servier are not practicable. And indeed, with his reference to Stellantis, these demands are apt to frustrate the vindication by the health services of the right to compensation. There is a second point not made by the judge, which I would make, and that is that in the case of a single PCT claimant, also, it is still not just or fair or reasonable for Servier to advance this sort of open-textured defence alleging failure to mitigate, which is going to be fleshed out later in the light of disclosure that they will call for. The conduct of Servier aimed at undermining the very measures it now says should have been taken points decisively against allowing Servier to run this sort of case. But even without the findings made of that conduct, there would be tenderness shown to the claimant in relation to what would have to be shown to constitute unreasonable failure to mitigate. And in the circumstances of a competition claim of this kind, which is designed to protect the purchaser, and where so much does turn on weighing local priorities and dealing with local pressures, that is why Servier would need, in the case of a single trust claimant too, to allege a breach of clear standards of accepted good practice. So, my lords, for those reasons, we say that ground one, the major ground, should be dismissed.
Because you could say, couldn't you, that unless the individual PCT was in breach of those general standards of good practice, so there isn't a general breach, what it actually did in practice is neither here nor there.
Yes. Yes, that is our point.
Because you can delve as much as you like and criticise individual consultants or individual managers as much as you like, but if there isn't a breach of the general standards, where does it get you?
Yes.
It doesn't get you anywhere.
Yes, and therefore, for that reason too, in addition to the judge's point about case management, we have a multiplicity which says it's to be dismissed. So I turn then to grounds 2 and 3, the contingent grounds. And I propose to make a couple of preliminary observations about both of them and then deal with them individually. The first preliminary observation is a basic point, the test for overturning a decision of a trial judge on a finding of fact. We cited in the skeleton, but scarcely need to, the judgment of Lord Justice Hamblin, as he then was in Haringey and Ahmed. A finding of fact can be challenged if it's unsupported by the evidence or where the decision is one that no reasonable judge could have made. And here, the point, my lord, that you made in the permission ruling is that this is a case where Servier's allegation in this appeal is that the judge should not have rejected unanimous expert evidence on the issues in question. And so that is the central target which I will address.
Yeah.
The short answer to it is that the two issues in question, grounds 2 and 3, were not matters of objective scientific fact on which the judge reached a determination. They were evaluative issues of what was reasonable or appropriate for primary care prescribers, considering the best interests of their patients. And that depended on other factors too. And those other factors reasonably included following the opinions of a respectable body of acknowledged specialists in the field. And I come back to what I said when I stood up originally yesterday. The essential context was that at the time, there was a divide between specialists who were content to assume that drugs in the same class were broadly interchangeable, what they've called a class effect, and others who based their prescribing decisions on specific studies where you had an evidence base supporting the use of a specific drug in the class. And that was the gist of the expert evidence which was led at the trial about prescribing practices. That point was accepted by the judge. And so as a general matter, it is wrong to suggest that the trial judge accepted unanimous expert evidence running to the contrary. And to show you that point, go back to the first document that I referred to yesterday on page 132 in the judgment, paragraph 197. Sorry, on the previous page I'd referred to this, this article in which the authors had referred to the fact that each of these drugs may have had different properties, and where they said that the not in common actions, halfway down page 131, could enhance or diminish the overall health effects. Over the page 197, following that article, the judge begins at the top. I consider that this shows there was not a consensus among experts at the time as to the extent to which ACE inhibitors were to be regarded as equivalent in treatment of indications other than uncomplicated hypertension. And then he records that Servier's expert, Professor Brown, accepted there was a genuine academic debate around the issue of a class effect. And although he said that the majority of specialists agreed with him. And then on the other side, the claimants expert, Dr. Durden, put it differently. And just to look at the second of those quotations, over the relevant period, there was a big debate between those who, like Brown, were content to assume that drugs in the same class were more or less equivalent therapeutically, in the absence of direct evidence to the contrary, and clinicians who considered individual drugs should be prescribed only where there was a significant evidence base supporting their use. So that was the state of matters at the time in the relevant period. And as you will see shortly, there were important evidence studies which a body of acknowledged specialists viewed as supporting perindopril, Servier's drug, either alone or with a diuretic, in these two fields, major adverse cardiac events, heart attacks, and post-stroke treatments. So now I turn to the two grounds. MACE, major adverse cardiac events, that is ground 2. The thrust of this ground is that the judge was wrong to find that in the relevant period there was a respectable body of opinion that one could have greater confidence in perindopril. So that's their case. And within that case, they have 4 subpoints. The first is the point that in reaching that finding, the judge was rejecting unanimous expert evidence. He had no business making that finding. Second, that the evidence on which the judge did rely didn't support his conclusion anyway. Third, the judge misdirected himself, finding clinicians would be acting reasonably by following the views of leading cardiologists. And fourth, that the judge wrongly relied on an admission in their defence. As I foreshadowed yesterday, the essential difficulty with Servier's argument is that it confuses 2 things. It confuses the question that the court is seeking to answer. Here, was there a respected body or respectable body of opinion at the time? With a question of scientific fact on which the evidence given by an expert pharmacologist could be determinative. And that is clearly wrong. In his oral submissions yesterday, Mr. Pitchenin sought to meet that point by claiming that what one should do is interpret the phrase respectable body of opinion so that it means an opinion in line with what a pharmacologist called at the trial believed to be sustainable. And his basis for that submission was paragraph 31 of the judgment, which starts at page 87, the foot of the page. And I will say that his suggestion was rather puzzling when you read this. If you begin at the very foot, last line, However, for its part, Servier at times seemed to argue that this depended, this is the reasonableness, purely on clinical equivalence and was solely a question of expert evidence on that issue. The question is not whether ACE inhibitors have a so-called class effect, and deliberately so. Moreover, although expressed in the alternative, I think reasonable and appropriate effectively go together. If it was not appropriate to prescribe another ACE inhibitor instead of perindopril, it would not have been reasonable to do so, and vice versa. That's to be assessed not on the basis of a doctor's preference for perindopril through ignorance, misunderstanding or bias, but on whether there was an objectively rational basis for the prescriber to decide that perindopril was more appropriate than another drug. Now, Mr. Pitchnin says that by use of the phrase objectively rational, the judge has in mind evidence aligned with the opinion given by the pharmacologist at the trial of the preliminary issue. But it is clearly not the case. By using this phrase here, the judge was distinguishing situations of ignorance, misunderstanding and bias. He did not mean to suggest that following the views, GPs following the views of acknowledged specialists was anything other than reasonable and appropriate. And that is the very point which the judge amplified in paragraphs 175 and 176, which I took you to earlier this morning, where he refers to the respectable body of opinion, page 126. That is the series of paragraphs in which he says that clinicians at the time won't have had the benefit of hearing the views tested in a courtroom setting. So then I turn to the judge's findings of fact that there was a respectable body of opinion in favour of perindopril for cardiac events, MACE. And for this, I begin with the description of the Europa evidence study, which was published in 2003 and concerned perindopril. You find that on page 101, at paragraph 84. You see from the title of the study, European Trial on Reduction of Cardiac Events with Perindopril, Europa, the acronym, what it was concerned with. And you will see, reading down, about 8 lines down just before the quote, the authors note their findings extend the observations of an earlier study called HOPE, in which cardiovascular events were reduced with ACE inhibition in high-risk patients with coronary heart disease. And they commented the risk level in our patients was lower than in HOPE, which selected patients aged 55 years or older who had cardiovascular disease or diabetes, plus at least one additional cardiovascular risk factor. They distinguish it. In our study, almost a third were younger than 55, fewer had diabetes and hypertension, more used aspirin, beta blockers, and lipid-lowering drugs. And so you see the way that the study is presented by its authors here, and this is important because it was a consideration that comes to be relied on by the judge in the reasoning later, which Servier disregards in its submissions.
So in other words, the Europa study was a specific study of perindopril, which actually demonstrated, or the conclusion was that perindopril was more effective than other ACE inhibitors.
It didn't compare perindopril with the other ACE inhibitors. What it does is provide evidence of the effectiveness of perindopril, the drug that it had tested, and the comment made is that their study is dealing with a different group of patients materially, and therefore extends the HOPE one for the reasons given in the quotation.
No, the reason why I asked that is because I noticed at the end, in 85, the judge says the study led to perindopril's license indications being extended in November 2005 to cover MACE as set out in the table above.
Yes, what he means by that, I believe,
That's the table at paragraph 71.
yes, is that the licensed indications for the use of perindopril,
Mhm.
which he makes a point elsewhere in the judgment, prescribers don't have to
Yeah.
abide with,
It's footnote
did
five.
not cover MACE until that point.
It's in that table, it's footnote 5.
Yes. So we see, therefore, that the presentation of the study itself on its own terms is that it is wider than the HOPE study which has preceded it. And then if you go forward to page 118, at paragraph 152, you see the way that Servier itself deploys the Europa study when interacting with physicians at every level. And I can concentrate on the quotation at the foot of 152. The aim is to use Europa and the sub-study results to differentiate Coversil from other inhibitors and ARBs, to gain support for formulary listings, to aid maximum freedom to prescribe and sell out in primary care. In order to achieve this, it will be also necessary to show economic analyses of Europa to show the benefits and costs of treatment with Coversil.
Yeah.
So they are then harnessing this at the time. And if you go to paragraph 163 next, a few pages on page 121, you have the quotation from their pharmacology expert, Professor Brown, in 163, which I've already briefly referred to. In relation to their deployment of the Europa study, he was asked, do you consider that this was capable of producing an impact on the specialists? Answer, my lord, the simple answer is yes.
Yeah.
And then if you go, there's a lot on this, but if you go over the page to 122 and paragraph 165, you there have Servier's own internal assessment of the reception in the clinical community of the Europa evidence study. And you'll see that Coversil was often perceived as having a poor evidence base compared to the other leading ACE inhibitors. Then they talk about how Europa has changed that. And to pick it up about 8 lines down, they say many previously negative cardiologists believe Europa is now the definitive study of ACE inhibition in coronary heart disease and have changed their prescribing as a result. Over the last 12 months, Coversil usage in cardiology has grown by these factors. These data reflect the newfound confidence and belief that cardiologists now have in Coversil as a result of Europa. So Servier sees that the evidence study has had this major effect on the clinical community. And now if you turn from that to the section of the judgment which deals with the condition MACE, it starts on page 134, paragraph 205. Perhaps I can just take this before the short adjournment. The heading at the top of the page is MACE. This is the material part of the judgment on which Servier's counsel focuses for the purpose of their submissions on this ground. And you see that at 205, it begins by referring to Europa and how it was seen as giving a strong evidence base for the effective use of perindopril, including in groups of patients, those under 55, which the HOPE trial hadn't addressed. And if you look at paragraph 207 at the end, there is where the judge refers to prominent and respected cardiologists who considered there were objective grounds to prefer perindopril. And then you have the particular paragraphs that form the focus of my friend's submissions, 208 to 210, which the court has already seen, but referring in particular at 208 to 2 distinguished cardiologists and what they wrote at the time about the evidence base for perindopril for this condition. And you see at the top of the page on 135 in the quote, they refer to positive effects on the endothelium and other target organs restoring normal function and structure. So this is not separate from a health impact. This is precisely because of the impact on health of the patient. And that is the context in which they go on to say many of these studies place perindopril apart. In paragraph 210, to come down to the conclusion, you see that the judge relies not only on the opinion of some prominent and respected specialists, but also on the presentation of the Europa study, which is why I took you to that straight away. That was the part that Servier's appeal submissions had ignored. There was a wealth of evidence that clinicians regarded that as a reason to prefer perindopril, which I've now shown you in Servier's own recording of what happened. Servier's appeal disregards it, and its skeleton wrongly asserts that the respectable body of opinion is the books and articles referred to in paragraph 208 and 209. Now, in our submission, that in itself is sufficient. But there is also all the additional material showing the extent to which the Europa study was treated as very important in the clinical community. My Lord, is that a convenient point? I've got
Yes, 2 o'clock.